On March 7, 2016, the United States Court of Appeals for the Ninth Circuit heard oral arguments in AKH versus City of Tustin, a 2011 federal civil rights lawsuit over the fatal police shooting of Benny Herrera. The plaintiff, AKH, represents Herrera's minor children, identified per Federal Rule of Civil Procedure 5.2's privacy protections. On December 11, 2011, officers Osvaldo Villarreal and Brian Miali responded to a domestic dispute. Though dispatch noted Herrera was not known to carry weapons, Officer Villarreal confronted him as he walked away. Dashboard footage and testimony show Villarreal ordered Herrera to remove his hand from his sweatshirt pocket. Herrera complied, but as his hand moved in an allegedly arcing motion, Villarreal fired 2 shots within 1 second of his command. The case centered on whether Villarreal used excessive force under the Fourth Amendment and whether qualified immunity, which shields officials unless they violate clearly established rights. The defense sought summary judgment, a legal motion asking the court to rule in their favor without a trial because the undisputed facts show they should win as a matter of law. They argued that under Tennessee v. Garner's fleeing felon rule, the shooting was justified. After the district court denied this motion, finding that factual disputes required a jury's determination, the defense appealed to the Ninth Circuit, seeking dismissal before trial. The case was heard in Pasadena, California, before a 3-judge panel consisting of circuit judges William Allen Fletcher and Mary Murguia and District Judge John Byron Owens.
Good afternoon, Your Honors. May it please the Court, Lois Boback for Tustin Police Officer Villarreal. This is a tragic case. There's no question about that. But Officer Villarreal was required to make a split-second life-and-death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He kept his hand in the front pocket of his hoodie sweatshirt. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that. He saw.
I looked at the dash cam from the 2 vehicles. His is the second vehicle that arrives, correct?
Correct.
So he didn't see all of it.
Well, he said that he saw Mr. Herrera on the shoulder of the roadway because he could see that before Officer Miali's car blocked his view of Mr. Herrera. So he saw him on the shoulder of the roadway with his hand out of his pocket. Then he saw him when he moved in front of Officer Miali's car out of a position of relative safety into the roadway. He saw him skipping and running backwards in the street, all the while holding his hand in his pocket.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Well, I don't recall at what point his camera was turned on, but he testified.
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see.
I understand your point, Your Honor. He certainly was able to see Mr. Herrera in the street.
Oh, sure.
And he saw him with his hand in his front pocket. He saw him, and he knew he didn't start in the street, so he knew he must have come from somewhere. But he had his hand in the front pocket of his hoodie. He was acting strangely. I mean, he was skipping backwards in the street. He was running backwards in the street. And then as the officers moved to box him in, the moment at which he had to make his decision, at the time that he ordered Mr. Herrera to take his hand out of his pocket or to show his hand, his intention was, once the hand was out of the pocket, assuming that Mr. Herrera had calmly stood where he was and moved his hand out of his pocket, his intention was to put Mr. Herrera into a control position, to get him down on his knees or down on his stomach on the ground so that they could take him into custody.
That was his intention, you say?
That was his intention, and
now,
that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision. Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket,
Yes.
and as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. As soon as he began to take his hand out of his pocket, he also moved quickly toward the front windshield, the front passenger window of Officer Villarreal's car, and brought his hand up in an arcing motion. That's when Officer Villarreal had to decide, is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right
he had a fraction of a second to make
Well,
that
don't we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities. He did it peaceably or he did it in reaction. So I'm just struggling with, in light of the standard that we have, here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So if that is the case, how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that was wrong.
Is it significant that is it Miali?
Miali.
Didn't fire? Chose not to
no,
fire? I mean,
because
it seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. First of all, well, I'll answer your question directly, and then I'd like to go back to the standard. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition, that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall. Officer Villarreal didn't fire in the direction of anyone other than Mr. Herrera. Mr. Miali would have had to fire potentially in the direction of, in the videos you can see that there are other cars. So there are other people that could have been hit by a bullet from Officer Miali's gun. But aside from that, Your Honor, the standard is whether or not it was objective reasonable, whether or not every reasonable police officer faced with exactly the same circumstances that Officer Villarreal faced would have concluded that firing under those circumstances would have been a violation of the Fourth Amendment. The fact that one reasonable officer decided not to shoot, and his circumstances are slightly different, but the fact that one person decided not to shoot doesn't mean that it wasn't objectively reasonable for officers.
Attorney Mary Lois Boback argues that Officer Villarreal had to make a split-second decision, which could be life or death in the situation. According to Graham versus Connor, the U.S. Supreme Court established that an officer's use of force must be evaluated through the lens of the Fourth Amendment, allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. This prevents judges and juries from using 20/20 hindsight, which is the phenomenon of being able to see things more clearly after they have happened. Instead, they must look only at what the officer knew at the exact moment they pulled the trigger. If a reasonable officer on the scene might have perceived a threat, even if it turned out there was no weapon, the shooting is considered lawful. According to Ms. Boback, just because Officer Miali didn't shoot, it doesn't mean the shot was unlawful. Judges William Allen Fletcher and Mary Murguia, on the other hand, point out that the dispatcher explicitly told the officers that Herrera was not known to carry weapons. They question why the officer would assume a weapon was present when the specific intelligence provided to him suggested otherwise. Also point out the fact that Officer Villarreal fired the shots in less than 1 second after commanding Mr. Herrera put his hand out of his pocket. Judge Murguia reinforced the applicable standard of review. Because the city of Tustin was bringing an interlocutory appeal regarding a denial of qualified immunity, the appellate court is legally bound to view the evidence in the light most favorable to the non-moving party, which in this case is Mr. Herrera's family. This is a specific procedural constraint. In an interlocutory appeal, which happens before a trial has even begun, the court lacks jurisdiction to resolve factual disputes. This means the court must assume the plaintiff's version of the facts is true for the purpose of this hearing.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
And right now we're talking about your facts.
As long as
Stick with theirs.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case,
right,
at this stage, we have to accept their version of the facts. So you need to explain under their versions of the facts why, as a matter of law, you win.
Under their version of the facts,
yes,
nobody disputes that Mr. Herrera was acting erratically. No one disputes that he was skipping backwards in the street. That's very strange behavior. Nobody disputes that it was almost simultaneous when Officer Villarreal directed or ordered Mr. Herrera to remove his hand from his pocket, that he started moving toward Officer Villarreal's car, and that he had his hand going up in an arcing motion. That's on the video. That's undisputable.
So if we take those facts,
yes,
you're saying that as a matter of law, Officer the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed. But that's not the same thing as saying he wasn't armed. If they had gotten a call that said, through dispatch, that said he's not armed, we know for a fact that he's not armed, this case might be different. But they were told he's not known to be armed. His behavior certainly gave them reason to suspect that he might be armed.
But doesn't our opinion at Espinosa clearly favor, or somewhat favor, denial of qualified immunity under these circumstances? I don't know if you're familiar with Espinosa, but it seems to be.
I'm sorry, Your Honor, I don't believe that I'm familiar with the Espinosa decision.
In Espinosa, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor. Espinosa versus City and County of San Francisco?
Yes.
I think that one of the things that the court said in that case was that there was a dispute about the historic evidence. Some of the officers argued or said that one of the things that they believed gave them exigent circumstances to go into the house and go into the attic was the fact that they saw a bloody shirt. And some of the officers said it looked like fresh blood. Other officers said it looked like dried blood. And so whether or not there were exigent circumstances, whether it...
But here, the domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
No, it wasn't an ongoing domestic violence incident, but they were investigating. He was a suspect in a domestic violence incident in which it was reported that he hit somebody on the head. That was the purpose for stopping him. And at the time, they knew that he was on parole, that there was a warrant out for his arrest, that he had known gang affiliations. And all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really
Counsel,
pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
And that's not what we're doing right now. Again, this is not trial court part two. This is a very limited inquiry, what we have to do here.
I understand, Your Honor. I'd like to reserve a minute and a half or so of my time, but I'd like to just briefly respond. The standard of review on qualified immunity, again, it allows for reasonable mistakes. And as long as the mistake was objectively reasonable, then Officer Villarreal is entitled to qualified immunity. I'd like to reserve the balance of my time.
Let's hear from the other side, and you will have some time.
Thank you.
Ms. Boback finished her argument. Judge Owens clarified that this proceeding was not a jury trial where factual disputes are weighed. According to Ms. Boback, Mr. Herrera's behavior was the reason for the events. Her statement is that no one argued that Mr. Herrera's conduct was adequate. Also, the fact Officer Villarreal knew Mr. Herrera was on parole, was a suspect of domestic violence incident, gang affiliation, and a warrant for his arrest were facts that raised the suspension for Mr. Herrera's conduct in a malicious manner. Under Espinoza versus City and County of San Francisco, officers cannot rely in split-second nature of the shooting as a shield if their own prior illegal or reckless conduct created the emergency. The judges argued that Officer Villarreal's decision to box in Ms. Herrera with his patrol car. They suggested that by closing the distance and removing his own cover, the officer created the very split-second danger he later used to justify deadly force. Because Espinoza versus City and County of San Francisco was decided in 2010 and the Herrera shooting happened in late 2011, the judges were checking if Officer Villarreal should have known, based on the Espinoza ruling, that his tactics and the subsequent shooting of an unarmed suspect were illegal. Following this exchange, Dale Christopher Gallipo, the attorney for the plaintiff, began his oral argument.
Good afternoon, everyone. My name is Dale Gallipo, and I'm representing or speaking on behalf of the appellees and the plaintiffs in the underlying case. I think the comment made, a lot of the arguments we believe they're being made here are more appropriate for a jury. Because in this case, there are a host of undisputed facts that we actually think favor the finding of the district court judge. And there's other facts that I think are either disputed or they're entitled to different reasonable inferences. And as I think was pointed out, for this limited purpose of today's hearing, one has to take all the plaintiff's facts as true and all reasonable inferences in their favor.
Well, let's look at what's undisputed, because I think it's a really interesting question we have here. When we look at what's undisputed, Mr. Herrera, and I think you could say suspiciously, kept his hand in his pocket, and that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. he responded to a command. He was given a command. He has a hand in his pocket, and he was giving a command to show his hands or take his hand out of his pocket. The officer was asked, "What was your intention?" "I wanted him to take his hand out of his pocket." One reasonable inference, again, is he took his hand out of his pocket in compliance with the command of the officer. When he took his hand out of his pocket, he had nothing in his hand. Another reasonable inference is that the officer could see that he had nothing in his hand before he fired his shots.
And what do you say in response to opposing counsels that he's entitled to make a reasonable mistake?
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Under our version, both hands were visible, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available, and that a warning that deadly force is going to be used should be given when practical. Officer Maile, based on his training, said, "I was watching very carefully, and unless I saw a gun come out of his pocket and point in our direction, I was not going to shoot. I saw his hand come out of his pocket. I saw nothing in his hand. I did not shoot." And so we believe if one takes all reasonable inferences in our favor, one could say he was complying with the command of the officer, he took his hand out, he had nothing in his hand, both hands are now visible with nothing in them. We believe that's a don't shoot scenario. And even if one could argue, as counsel did, well, this is happening quickly, officers are in a position to make difficult decisions, we believe that's a more appropriate argument for a jury. It's not an argument that lets them prevail as a matter of law. And we believe the district court got this right when she really carefully looked at this and decided this is really a jury question. Some of the other things that I think were mentioned were that the officers boxing him in, and we believe that played a part in the dynamics and his movement. It was also noted that he didn't take his hand out of his pocket and simulate a gun or point it at someone as if he had a gun. And so, I made a list of some of the undisputed facts.
And that would have made a difference if he had.
Maybe. Now, if it looked like he had a gun, in other words, if the officer would have testified, if the evidence was clear that he pulled an object out of his pocket that everyone thought was a gun and it looked to be pointed at the officer, maybe it's different. But in here, when you ask the officers, when you saw the hand come out of the pocket, did you see any object in his hand? No. Did you ever see a gun at any time? No. Did you ever see anything that looked like a gun at any time? No. So we believe that's what makes this case different. And I think if this case hopefully is sent to trial, both sides have good arguments to make to a jury, but we think a jury has to decide these disputed facts, has to decide the inferences that can be drawn from these facts, and ultimately decide whether they think the shooting was excessive or not. Part of our further argument is we believe that a jury could find that Officer Maile acted more reasonably by not shooting, given his observations and testimony, than the shooting officer did. And I think a jury can conclude that his decision not to shoot when he saw the hand come out of the pocket with nothing in it was a more appropriate decision. I don't know if any of you have any other questions for me right now?
No,
Okay.
No, thank you.
Thank you very much.
Attorney Dale Christopher Gallipo appeared on behalf of the appellees, the family of Mr. Herrera. Mr. Gallipo affirmed that in this oral argument, it had to take all the plaintiff's facts as true and all the reasonable inferences in the favor of the plaintiffs. Mr. Herrera complied with the officer's command. He showed his hands, which held no weapon or object. Mr. Gallipo argued this compliance removed any objective basis for the use of lethal force. In Tennessee v. Garner, the court ruled that a police officer may not use deadly force to prevent the escape of a fleeing suspect unless the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. He posed the critical question: was it reasonable for Officer Villarreal to perceive an immediate threat when Mr. Herrera merely removed his hand from his pocket in apparent compliance? Graham v. Connor, the court created the objective reasonableness standard. The use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. When determining if force was reasonable, courts must look at the totality of the circumstances, such as the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight, and in a split of just 1 second was not enough to make the decision, especially when the second officer, Officer Miali, did not fire. Finally, regarding police procedure and training, Mr. Gallipo noted that Officer Villarreal admitted in deposition that he was trained to use deadly force only in the direst of circumstances. Furthermore, constitutional standards, specifically established in Ninth Circuit precedents such as Diorl v. Rutherford, typically require an officer to give a warning before using deadly force whenever feasible. Mr. Gallipo highlighted that Villarreal gave no such warning. He issued a command to move hands, followed instantly by shots. Following Mr. Gallipo's arguments, the court granted Mrs. Boback time for rebuttal, allowing her to address the points raised by the plaintiff's counsel.
One in, I apologize if I mispronounce these, Peng versus Peng Hu, 2003 Ninth Circuit case 335 F. 3rd 970. The court said that when the historic facts are undisputed and the only dispute is the inferences that can be drawn from those undisputed historic facts, then, and this was a probable cause case, the question of probable cause is a question of law for the court to make. Juries should not be put in a position of second guessing whether or not an officer acted in a reasonable manner or not. The only province of the jury is to decide the undisputed facts, and I would submit that we don't really have any material undisputed facts in this case. We can see what happened on the video.
But counsel, we have jury trials on this all the time, and the police officer will bring in their use of force expert, and Mr. Gallipo will bring in his use of force expert to talk about what should have happened. I mean, juries do make determinations.
But they're not making determinations on qualified immunity, and that's the only issue in this appeal, qualified immunity, and whether or not the actions of Officer Villarreal were objectively reasonable in light of all of the circumstances.
You said something that confused me. The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
It's my understanding that the application of qualified immunity is a question of law.
Well, it is a question of law on undisputed facts or facts taken in favor of the other side, but I've never understood it to be outside the province of the jury when it goes to trial.
Well,
to say that the officer does not have qualified immunity.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point, if we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all. And if the jury were to return a verdict against Officer Villarreal, I think that he would have the opportunity to file a motion for a judgment notwithstanding the verdict on qualified immunity.
We're just looking right now on the undisputed facts in the light most favorable to the plaintiff, whether or not Officer Villarreal is entitled to qualified immunity.
That's correct.
Right.
That's what this court is looking at.
Right. And if we, in looking at the facts, and the reasonable inference, most favorable to Mr. Herrera, and that there may be reasonable inferences that could be drawn from those facts, or differences of opinion on what can be drawn from those facts, then we may not be able to make that determination as a matter of law. But you, when it goes back to trial, if that's the result here, can certainly argue to the jury why Officer Villarreal should not be held responsible and set forth that he should be immune from this.
I agree with
based on all the facts that are presented.
I agree with Your Honor that if this court finds that there is a disputed material fact relevant to the application of qualified immunity, then the case has to go back. The district court's decision has to be affirmed. I think that on the record before the court, the videotape evidence, the deposition testimony that we have, shows that Mr. Herrera's actions, Officer Villarreal's actions, are not in dispute. We know what happened. And it's just a question of whether or not a reasonable police officer, knowing the same things that Officer Villarreal knew, would have felt justified in firing.
Yeah, this is a question that's off to one side from the merits of the question we are now being asked to decide, so I want to make that clear. But I would like to know if you can answer this. If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
at that point, I got the answer. Got it right. At that point, I think the employer has the option. Yeah.
yes.
Okay.
Thank you, Your Honor.
In her rebuttal, Ms. Boback addressed the procedural division of labor between judge and jury. She conceded that while the ultimate determination of qualified immunity is a question of law for the court, she argued that a jury must first resolve disputed historical facts. These material facts include whether the suspect's hand was truly in his pocket, the velocity of his movement, and whether he was skipping or charging toward the officer. However, she posited that even if a jury were to resolve these factual disputes in the plaintiff's favor, the officer should still receive immunity under the second prong of the qualified immunity analysis. She argued that the law was not clearly established enough to put an officer on notice that using force in that specific high-pressure scenario was unconstitutional. Judge Fletcher, however, challenged this separation. He questioned whether the objective reasonableness of the officer's fear could be decoupled from the facts, asking if it isn't the jury's exclusive province to decide if a reasonable officer would have perceived the suspect's arching hand motion as a deadly threat. The panel emphasized that credibility determinations belong to the jury, not the court. They argued that if a jury found the officer's narrative lacked credibility, the factual predicate for immunity would collapse, making a summary dismissal improper. On September 16, 2016, the Ninth Circuit issued its formal written opinion, affirmed the denial of qualified immunity for Officer Villarreal. The court's key findings were excessive force, the 1-second rule, and clearly established law. The court held that it was clearly established that an officer may not shoot an unarmed, non-dangerous suspect, even though the Ninth U.S. Circuit Court of Appeals ruled that Officer Villarreal's use of force was excessive. The Orange County District Attorney's Office had previously found the shooting reasonable and justified in its own review, not following a criminal lawsuit with Mr. Villarreal. In 2017, the settlement reached a value of $1.4 million before the case went to trial. It was split among Herrera's parents and his 4 children. Officer Villarreal wasn't held accountable for the payment of the settlement. The settlement resolved the civil wrongful death lawsuit, but public information does not indicate any criminal charges were brought against him or internal disciplinary actions were taken beyond the lawsuit's conclusion. Officer Villarreal remained an officer and was even recognized, along with another officer, with a Distinguished Services Medal in 2017. This case illustrates just how different a perception of a civil and criminal court can interpret. Over the course of the oral arguments, the court was walked through the critical timeline of Officer Villarreal's actions, specifically the less than 1 second that elapsed between his command for Benny Herrera to show his hands and the 2 fatal shots he fired. By highlighting the simultaneous nature of the command and the shooting, the family's counsel sought to dismantle the officer's claim of a reasonable threat, emphasizing that Herrera was essentially shot for complying with an order he was never given time to process. The argument emphasized that while Officer Villarreal claimed to fear a weapon, the second officer on the scene, Officer Miali, notably did not fire, suggesting that the perceived danger was not a universal certainty, but a subjective and ultimately fatal miscalculation. Ultimately, the Ninth Circuit's decision to deny qualified immunity reflected the court's assessment of the investigation's core contradictions. Rather than granting the officer a shield of immunity, the judges ruled that a jury must be the one to determine if Herrera's arching hand motion was a genuine threat or a predictable response to a sudden command. This ruling paved the way for a $1.4 million settlement. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.